Right, thanks everyone for joining. John is a Liverpool fan. Is that all right for me to say, John?
Yeah, these days it is. Yeah.
It is at the moment, yeah. He wants to watch the second half, so I promised him we'll be done by half time. So we'll crack on. Thanks everyone for joining. Good to see some familiar names. And hopefully you enjoyed tonight's session. So hopefully most of you know who I am. So maybe we'll start with John tonight. John, do you want to give us a little bit of a brief on who you are?
Yeah, I'm a litigator by trade. I specialize in property and construction litigation, and I'm the managing director of Ridgemont, which is one of 3 specialist construction law firms in the country.
Yeah. Okay. So for the way I tend to look at it, and John, correct me if I'm wrong, is that they're the kind of firm that developers will potentially instruct directly, but they're also the type of firm that a lot of other solicitors will use when they have construction business where they don't have the expertise in house. Is that?
That's right. Yeah. So construction law is a very very specialist area of law. You can't go. So there are general practitioners in law who dabble in all sorts of things, and they can do that to some extent, but not in construction law. And the reason is this: that we've got our own legislation, our own way of doing things in terms of the supply chain, our own standard form contracts, and so it's so specialist that you need a specialist construction lawyer to advise you.
Yeah, so when we work with lenders, a lot of them will say to us, has your borrower got a specialist construction lawyer? And a lot of the time the borrower will say yes, because they've been told by their lawyer that they deal with construction. There is a real distinction between the two. Like, this is all John does, it's his area of expertise, it's what his company does. And then, as John just pointed out, there are people that will say they do it because they want to win the business, and they'll either muddle along themselves, or they might use someone like John in to help them through. So hopefully a valuable session for people who joined tonight, and for those watching back as well. We'll go through quickly what we're going to cover. So before that, just a quick intro on us. So hopefully most people know who we are and what we do, but we're looking really to bring the market to developers to ensure they get a better deal on their finance, and that normally means that we're able to search close to 40 lenders on every inquiry, and we're able to show you what each lender will lend to you and at what price. So gone are the days where you have to go and bang on doors and try and find the best solution and wait weeks for answers. You can get those answers immediately, and then you can make an application through the platform as well. So it's all very clean and easy. We'll do a little demo at the end for those that haven't seen it. So John, this is what John's agenda is for this evening. He's kindly set out what he feels are the most relevant topics for us to discuss tonight. So I'm going to ask a few questions and discuss with John, but really the floor is John's. So we're going to look through some of the common issues, the 5 main construction disputes, what lenders want, how to save money when using a specialist construction lawyer, and key action points to take away, which are universal and should be used across the board. So common issues. So John, do you want to kick us off?
Yeah, so it's 25 to 8 on a Tuesday evening. I don't think anybody wants to hear me talk about law. So surprisingly, in the session, I'm going to try to avoid talking about law altogether and talk about practical stuff that you guys should be looking out for, that affect developers and contractors. Now, the construction industry is beset by disputes, and there's a few reasons for that. Number one, the personality of those involved. 2, the contrary makeup of the contracts that we use. So it's not a collaborative approach, and as a result, disputes are the norm in construction, legal disputes. And so you really have to, number one, try to avoid them because they're expensive and eat into your profits. But number two, also accept that they're part of the business and prepare yourself in case a dispute does arise. And we'll talk later about the sorts of things that you can do now to put yourself in a great position for when a dispute does arise. Now, in terms kind of smaller developers, I've given some thought to the type of issues that come across our desks from smaller developers, and they're things like what we've got on the slide here. I think a key one is making sure you choose the right contractor. Now, so we advise developers and contractors and subcontractors, so we see it from both angles. But certainly between, say, I don't know, 3 and 30 units, it's quite difficult to get a substantial contractor to take on your development. And to some extent, you're therefore relying on a local builder and local trades who are small businesses. You know, they might have a group of labourers that they work regularly with, or it might be a one-man band. And so they don't have that kind of covenant strength that the bigger contractors will have. So when you enter into a construction contract with them, the risk is obviously that, number one, they could go under, or number two, they could behave really badly, but leave you in a position where you have to kind of bite the bullet and accept it. So for example, a builder that suddenly demands more money halfway through the build, well, you know, you may say, fine, refuse. They may suspend work altogether. You may say, let's terminate. But the reality is you're then going to have to find another contractor who's going to come in and charge a premium to finish off someone else's works. And you're going to really struggle to recover that premium from the original contractor. So I think at this level, it's actually not as simple as it otherwise would be. You really need to think about these issues carefully. You've got to do your due diligence on contractors, go and see their work, get references from their developer clients, and build up a really strong supply chain that you can trust. And certainly don't trust anyone in construction, because when money is at play, people start getting very contractual, and this is when the disputes arise. And it can make it really difficult to make a profit on the development if you've fallen out with a contractor and they're trying to screw you left, right, and centre on variations. And that could include things like at the beginning of the build, for example, where the drawings perhaps are not as detailed as they could have been. The understanding between the parties was that they would do certain things, which later on in the build, they turn back to the drawings and say, well, that's not in the drawings. We're not contractually obliged to do it. So I guess that's a second point, is to have a great architect. And we see a lot of problems with architects. And normally it's competence. So I think you need to, again, take references for the architects you're going to use. You know, you would think that all architects are suitably qualified and therefore able to take measurements and produce drawings that can be relied upon. And unfortunately, that's not always the case. They're not always as detailed as they need to be. And then sometimes they're just wrong. So find that great architect that you can rely on, and someone that you can build a relationship with. Now, architects may refer you to contractors, and in a way that's good, that's a reference. But remember, there's obviously a relationship there, and we're all cynical in this business. So there may be a very good reason why the architect is recommending that contractor, and it's nothing to do with their competence. So building up that strong supply chain is really important, and obviously having some options, because you don't want to be too reliant on one contractor. And what can happen is a developer can have 2 or 3 sites going at the same time with the same contractor. They have an issue on one of the sites, which means that maybe they really need to terminate the construction contract. But because of the fact that that contractor is on the other 2 sites, it puts them in a position where they can't, because they don't want to prejudice the developments on the other sites. So that creates some risk there. And then you look at procurement, so the form of contract that you decide to use. You know, at this level, probably the JCT suite of contracts is most appropriate. So you need to think of you know, whether you're going in and whether you're taking design responsibility, or you want the contractor to take on that role. And there's different types of payment mechanisms that you can agree, obviously. And very popular amongst contractors at the moment is cost plus, for obvious reasons. The price of materials and labor is going up all the time. So they don't want to be locked to a specified contract sum. So cost plus is attractive for them, but not attractive for you, because you don't have the certainty of what the bill's going to cost. Now, look, we've been in the business a while now, so we know that there's no such thing as a fixed price construction contract. Normally the contract sum in the contract is not the end price, because there's always variations, there's always issues on site. But if you can have that certainty, then in my view as a developer, that's got to be the best way forward. Then thinking about how you protect yourself against risk. So when you contract with parties, so for example, the contractor, what checks are you doing on their business? Company's house, there's financial information available, credit checks. Have the directors of that company been the director of companies that have been dissolved? So often you'll see small contractors where the directors have dissolved a succession of companies. And that's obviously a really bad sign, because you know what it means. It means that if you end up with a valid claim against them and you adjudicate and you win, they'll just wind up the company. They'll just fold the company, and you've got essentially a paper judgment. So that's particularly important to do your best on that, but bearing in mind that at the smaller end of the market, it will be smaller contractors who are interested in taking on the work. I've got on my notes here failure to be on top of interim payment regime and things like that. So construction contracts are obviously complemented by the scheme, which you can hear about in some of the videos on my LinkedIn channel. It makes it complicated, because obviously everything in the scheme has to be in the contract. So if it's not, then the contract's supplemented by the scheme. Anything in the contract which is contrary to the scheme doesn't work, and so the contract will apply up to that point, and then the scheme will apply. And the mechanisms, which I'm sure you are all aware in respect of notices and payments, have been made about as complicated as they could possibly be. The scheme came into play, obviously, to try to make to ensure the payment down the supply chain from main contractors to subcontractors was as quick as possible, because I think it was in the 90s, a lot of subbies were going out of business. So we're left with legislation, though, that is difficult to understand, and a unhealthy position where you're having to read the contract and the legislation at the same time. But my strong advice to you is to get familiar with it. You know, you can watch our videos, you don't have to go to legislation itself, and understand the contract that you're signing. Often we have clients come to us, developers and contractors, who either don't know where the contract is, or there's no written contract, and they think there's no contract, but in fact the contract is obviously made up of the emails and WhatsApp messages that have been exchanged at the beginning of the works. Or they have a contract and they've got a copy of it, but they've never read it. Or they've read it and they don't understand it. Now, you've got to have an understanding of the contract that you sign and the mechanisms that work, and how they work, basically. Because if you don't do that, this is so central to your development. And most of all, and what everyone on this call is interested in, it's so central to your net profit. All of these mechanisms result in net profit going one way or the other. And so it's something that you can control. You can't control some things in development, but your knowledge of the contract you can. So I encourage you to have a good understanding of that. And that goes into the next point of employers, developers not administering contracts properly. So because you don't have a full understanding of it, you're not enforcing the terms of it. And then something that Ian and I were talking about yesterday in a prep call for this session is how macro events in the world have caused issues in construction. So obviously Brexit had an immediate impact on the supply of labor and the cost of materials. COVID has made that even more so. And with the outbreak of war, again, we're seeing prices go up. And the reality is prices are going one way and they're going up. Again, eating away at your net profit. So what do you need to do about that? We'll talk later about fluctuations clauses in construction contracts. And that's one thing which contractors will be very keen on having in your contracts with them, essentially meaning that they're able to increase the price of certain materials during the course of a development to take into consideration price rises. But you need to be thinking about where that leaves you in terms of certainty and whether you could get to the end of your development and not make a profit. And obviously, you know, we're not all here to build beautiful buildings. We're here to make money. And we've got to be really careful that we don't enter into a contract which we'll later regret. So those are the common issues, I think, that you should be thinking about as a smaller developer. But obviously, there are issues that run all the way through to bigger developers.
Thank you, John. That's really comprehensive. On the point on contractor strength, just to sort of pick up on that, we talk all the time and we tell everyone that we speak to that it is probably the hottest thing for lenders at the moment. There won't be a lender out there that will not have a project where the contractor hasn't gone under. So they all are very scared of this. And they will, if you don't do the work, they will. And like with anything, when you go to get funding, credibility is a big point. And if the lender is telling you some of the things that John's just talked about, you know, series of dissolved companies for directors of the contractor you're using, their accounts look really weak at Companies House. You know, if they find this information, then your credibility immediately is undermined. So it's very good practice to do it, not just for the obvious reasons, but also for the fact that the lender's going to do it, and therefore you always want to know more than them, and be able to, you know, counter any objections maybe that the lender's going to raise. So that's one point. What I would say is certainly at the moment with contractors asking, I mean, the information that's at Companies House, normally it's redacted or I can't remember the terminology for the accounts at Companies House, but they normally don't tell you very much information. But what you can ask for is MI accounts, so management information accounts, which will give you much more up-to-date information and give you a much clearer idea of where they are on things. I've even known of borrowers ask for bank statements of contractors, just to confirm that they are liquid and they aren't right at the wire. So, you know, bear in mind that they will have other schemes that they're probably working on at the same time. So, you know, you hear of situations where contractors take a job and they're taking money from you, and that money's being spent on other sites, not yours, and things like that. So it is it's a very hot topic. I saw a headline a little while ago saying that 19% of all insolvencies in the UK at the moment are in construction, which is a huge number. So and it probably will get worse. So, you know, definitely I think referrals from your network are really useful. people have had good experiences. Definitely speak to several. Last project I did, I spoke to 4. One was the architect's recommendation, one was a friend, one was somebody else, and you met them all, understood, where the strengths and weaknesses were, and ultimately you got to get along with them as well. But then we did the financial DD once we got past, the initial meet, and understood, who was in the best financial position, and that definitely influenced who we went with. So definitely something to do. John, one thing I do just want to ask, if you were self-managing, so if you were subbing the work yourself, how would that differ in terms of your approach with contracts?
Well, first of all, I'd be hesitant to do it unless you were sufficiently experienced. In terms of contract form, then you would be contracting directly with the subcontractors. Is that what you're talking about?
Yeah.
Yeah. And I suppose
is it the same process 4, 5, 6 times, or is it, do you take a slightly different approach?
Where you really want to get to is where you're using similar contracts with each one, so that, going back to my point about understanding contracts, it's impossible to understand 5 or 6 different contracts.
Yeah.
And actually I've been dealing with a similar matter today, where a developer is developing a site in a nice part of West London, and they're wanting to accept the separate terms of the different contractors and consultants rather than having standard appointments. My view on that is that it's crazy. Not that the terms and conditions that they're offering are particularly onerous. If they are, my colleagues looked at it, not me. But again, go back to the point of how can you understand and have a full grip during the whole course of the development on all these contracts? The reality is you can't. You need to know where you stand.
Okay.
The other point I'd make is, of course, that if you've got a main contractor between you and these subcontractors, it's someone else to go after when it goes wrong.
Yeah. I think for the people that will do that, they, to your point, they generally will have a construction management background, so either be project manager or development manager, or just have sufficient experience. So yeah, we I don't think any lender's going to back anyone that's not done it before, so it's definitely for experienced people, but just wanting to understand the mechanism. So main types of dispute, defective works, number 1.
Right. Okay. So essentially, there's 5 different types of construction disputes, main types of disputes, and it's really important that you have an awareness of them, because these are the things which will affect you. And there's probably some people on this call who've had some of these issues. So number 1 is defective or outstanding works, a claim against a main contractor, probably. There could be some delay as well. Now, when you're making a claim in respect of delay, for example, you're talking about bringing specialists in to look at the critical path, produce a report, and somehow explain to an adjudicator, spoon feeding them, how the event has caused a delay of the scheduled works. That's difficult to prove, and it's really expensive to prove. So avoiding delay as far as possible is super important, but delay is part of construction, and it's something which everyone will face at some point. Defective works, again, normally on site there is something which is defective, and normally it can be remedied, but obviously depending on the value of those works, you may or may not want to claim against the party that's responsible. When you're thinking about making a claim in construction, you need to stand back and think of a couple of things. Number 1, what is the value of this claim? So let's say that there's defective works to the exterior of a property, and the value to put it right is £40,000. Starting an adjudication for £40,000 is difficult. So the legal costs of an adjudication are normally about 20,000 or something like that. So it doesn't make any economic sense to pursue a contractor for that kind of money. So number one is to pick your fights, and you know, if something's worth 150,000, then by all means it's worth looking at. But if it's 20 to 50, then I would say probably you can instruct a lawyer to write a letter and to try to negotiate a settlement, but you don't want to be going to adjudication or through the courts. If you go through the courts, essentially adjudication is a short form version of a trial. 28 days, the adjudicator's got to make their decision. Very fast process. It's not an adverse cost environment. So it means that if you spend 15, 20,000 legal costs, you can't get them back even if you win. Whereas if you've got potential claim in respect of defective works, you could litigate, go through the courts. And of course, if it goes into the county court or high court, that is an adverse cost environment, which means that if you win, you're likely to also be awarded your costs. 2 points. One is, if you're suing a contractor, will they have the money to pay your costs? And number two, in any litigation, there's always costs that are not recoverable. So it might be certain elements of advice that you've received from your solicitor, which doesn't specifically relate to that case, it's sort of tangential things. It might be that the cost budget, which is the budget for the legal costs that's agreed between the parties and the court at the beginning of the litigation, means that you can't claim the £15,000 you spent on your witness statements. You're stuck at 10,000. So you've got to be thinking, well, if we litigate this, the value of the claim is 50,000. If we litigate, let's say we get 70%, which is probably the national average, we'll recover 70% of our costs. So if we spend 100,000, we get 70,000 back. So you need to do your maths and see if it's worthwhile, taking into consideration the cost of your time in managing that litigation, and the focus it will take away from the development. Smash and grab. So that's obviously where there's no valid payment notice or pay less notice, or for example, it's late. And so there's a claim for payment of a notified sum. And it's a technical claim, and the reality is this, that even if the works on site have been significantly overvalued, so let's say the valuation for that month is 100,000, but in fact they've only done £20,000 worth of work, because you've missed your chance by failing to put in that pay less notice, it means that you're probably going to lose the smash and grab adjudication. That also means that you've got to pay the adjudication award before you can do anything else. The next step in those circumstances is to start a true valuation adjudication, saying we don't think the value of these works is £100,000. We think it's £20,000, and we want a decision from an adjudicator saying the same. But remember, you're going to have to cash flow paying that first award before you can start the second adjudication. And you've also got 2 lots of legal costs on 2 adjudications. So again, do your maths. Is it worth it? Often it is, but I'm not the sort of lawyer who encourages people to spend money where it has a negative impact on net profit rather than a positive one. So you need to be thinking about that. Then we see disputes between main contractors and subcontractors, normally regarding either defective works, delay, or payment. And what you will see as developers is you paying the main contractor on time. But if the main contractor's got cash flow issues and potentially has issues on other developments, it might be that, as Ian said, they're using your money to pay subcontractors on other sites that have got nothing to do with you whatsoever. And so I think at the first instance of your suspicion of that, you need to raise it with the main contractor and try to understand exactly what their situation is, because you obviously want your subcontractors to be paid, because they're either not going to turn up or they're not going to do a very good job if they're not being paid properly. I think that's key. Obviously, a claim between a main contractor and subcontractor doesn't directly affect you in that you're not a party to that dispute. But you've got to think about the relationships on site and the progress of the works. And I think that having an open dialogue and trying to build a good relationship with the main contractor and the subcontractors on site will help avoid those disputes happening. And then finally, it's a claim for negligence against a consultant. So I've given an example of an architect, but it could be a structural engineer, it could be anybody. We've dealt with many claims against architects, as we have structural engineers, where the drawings have been wrong, calculations are wrong. And as a result, works have to be ripped out and started again. And even if you've got a good claim against these consultants, query, is your funding going to be sufficient to have a contingency to pay for these unexpected works? So I suppose having a significant contingency is really important. And also doing your due diligence on those consultants before you appoint them, and making sure that the contracts that you have with them, the appointments, are leaning towards your favor rather than theirs.
I guess with any of these things, the minute you start looking at adjudication or any kind of dispute resolution, every work's going to stop on site, right? So you've got to factor that in. I guess it's almost the same as your contractor walking off site to a degree, because however long that adjudication process takes, no work's going to be done by that contractor. Depending on what the dispute is, can you get rid of them at that stage, or do you need to wait until the adjudication has run its course?
So it depends on the nature of the dispute. It may be that the contract is in repudiatory breach, in which case you can terminate. And there is some risk involved in that, obviously, because if it's ever decided that they were not in repudiatory breach, then you were in repudiatory breach for terminating on that basis. Right. And going back to the circumstances that I was trying to explain earlier, it's actually at this level more complicated than simply terminate, because of all the issues that I discussed earlier about, well, what are you going to do next?
Yeah.
Do you really fancy going to your funder and saying, I want to terminate my main contractor? I want another contractor in. How are they going to react? And Ian, you tell me, how do funders react to things like that?
Good question. I must admit, I've not actually had any experience of seeing that happen. We have had situations where we've seen sites be delayed and costs rise significantly, but not. I can't think of any examples where both sides have completely fallen out. I know of one where the contractor, the main guy, had a heart attack and died partway through a scheme. That obviously caused a lot of complications, and so there wasn't that there was a dispute, but they had to be replaced because they were no longer able to fulfill their contract. So yeah, look, a funder's going to hate it because invariably you've probably borrowed the maximum of what that funder will allow. So any delays, any changes in cost are going to have to be borne by the borrower. And in cases where the borrower isn't able to cover that, then they're going to be looking to the lender. And if the lender can't do that within their model, or if GDVs increase during the phase between the initial loan draw and when this situation arises, then obviously there's potential they could lend more money. But if GDV stayed the same or worse dropped, then the lender's going to be looking at calling calling you potentially on a covenant breach, and then you start getting into the situation of, well, how do you finish the project? I mean, one thing I would say is that, you know, lenders never want to pull the plug. If there's a way forward, they will find it with you. But I mean, I think all of this comes back to what we talked about at the start, is finding the right, doing the work at the start to make sure you're getting into bed with the right people, I guess, because, you know, this, whatever happens, you know, there's no real winner in this situation. If you go to dispute, it's going to cost you money. It might cost you the site entirely. It's going to cost you a lot of time, a lot of stress, and all of that could be avoided, presumably by working with the right people. I mean, there will be instances, I guess, where you know, a contractor could come under financial stress through, you know, and they've not done anything wrong per se, but, you know, they've victim of circumstances, macro events, as we touched on earlier. So, but I think, you know, by doing the things we talked about earlier, then you just reduce those chances.
Yeah, and that segues nicely into fluctuations provisions. So one of the issues that contractors can have is that where they're stuck in what would otherwise be a fixed price contract, as far as it goes, the price of labor or materials rockets. And that's what we've seen over the last, well, it's certainly been going up over the last 5 years, but over the last 2 to 3 years, it's been incredible. And the price of timber and steel and concrete and cement is all going up because of the events that are happening, the global events. And so contractors will be super keen to have fluctuation provisions in their contracts.
And what do these normally look like, John? Like what kind of percentages, or is it uncapped?
It can be uncapped, but obviously that's a commercial point. Obviously I think that those listening to this will have a fair idea that's risky business, having an uncapped fluctuations provision. But essentially it means that if the price of timber goes up 30%, then the contractor is going to look at you as the developer and say, I want that 30% off of you. Now, given that when you first spoke to Ian and got your lending of, say, £1 million, the cost of timber for the project was, say, £100,000, and now it's £130,000. What you've borrowed won't cover that £30,000. So presumably, Ian, they then look at you, the developer, and say, what should I do?
Yeah.
And the answer to that is difficult, isn't it? Because you might be able to squeeze the lender a bit to get a bit more money out of it. You might be able to value engineer the works to try to, make room for it in your budget. You might have a contingency fund which you can dip into. But there are clients that get into difficulty when the cost of the contract increases, and this is one way that it can do. What I would say is that there's some materials, for example, steel, which you can order in advance. So one way around it is for the developer to forward fund the forward purchasing of the materials to avoid that specific material being part of the fluctuations provision.
Yeah, and I mean, you do hear of some contractors when they're pricing, guaranteeing a price for a period, and they'll actually, you know, their forward flow or cash flow that material themselves, like hedge the cost. So yeah, there's a deal we're looking at the moment, which is construction of a hotel, and that's quite a large build, and the contractor has done that. But I think in the past, you know, you might have seen a guaranteed price for a period of time, and it might have even run as long as, you know, 3 months, 90 days maybe. But I think the latest revision of the cost is guaranteed for 10 days only, and this is, you know, fairly big contractor recommended by, you know, a big hotel brand. So one of their preferred contractors that the developer's using, and for them to be in that position when they can only guarantee the price for 10 days is, I mean, it kind of, you know, they've got you over a barrel to a degree, haven't they? You know, you haven't got long to, because you know at day 11 that price is going to go up again. So you need to make quick decisions. What going back to, obviously uncapped is no one's favorite thing, but what do you how do these things normally tend to be worded? Is it, if like timber today is X, any movement in that price is back on you? Is that how it's worded?
So you'll have a base date in the contract, and the prices of those materials will be set out around that date, and then any increase from those prices from that date will then form part of the whatever's been agreed in the fluctuation provision.
Right.
So as I think as a smaller developer, you've got to be really reluctant to enter into it. But having said that, what's more expensive, paying 30% more for your timber or your contractor going out of business? And this is a point I wanted to raise. And I know that I sound like a miserable sod, but I'm a litigator and I see all these things every day. If you go for the cheapest contractor, or if you negotiate your contractor down, you screw them down to so much on price, where they're going to have to try to find their profit in the job somewhere else, or they're simply just going to be making a loss. And at some point during the development, they're going to lose interest and want to get out. So I think, although we can make the contracts leaning towards you, the contract's got to work for that relationship. And whatever price you agree with the contractor, it's got to be realistic. If you get 3 quotes and one is 20% lower than the other 2, you need to ask yourself, and probably ask the contractor, why is it so low? And be very careful about engaging a contractor who where it appears too good to be true. Yeah,
I've seen that myself personally, where had somebody quote like an unbelievable price, and it was unbelievable for a reason. We got to the next round of like actually doing a proper pack of information over, and they'd grossly missed or underpriced, and it was, I think, just a tactic to kind of, you know, get you further along the process and hope that, you know, because you've invested your time and that with them, that they would win the deal. But it didn't work. Didn't their cost change by about 20%? It was just, and actually one of the other chaps we were speaking to at the time said they can't fulfill at that price. Like I was trying to get him down to the price that had been quoted. He said they can't do this job at that price. Like, trust me. And I was dubious, and he turned out to be correct.
Lesson learned, right?
Yeah, there you go.
Hopefully those watching this will learn from your mistake rather than doing it themselves. So moving on to force majeure, which has obviously been in the news a lot over the last couple of years, from a pandemic to a war. And, you know, we're advising contractors and developers on issues that are arising, for example, out of the Ukraine war. So we're advising on a very significant development just outside of Kiev at the moment. Now, touch wood that the war will end shortly, but it's the ramifications of the war in terms of the pricing of materials, in particular, will continue for some time. The first thing I wanted to say about force majeure is that there's a lot of clients come to me and say, there's no force majeure clause in the contract, but it's okay because I've got a common law right to force majeure. And frankly, that's bollocks, if you don't mind me saying so. If it's not in the contract, then there's no right to any kind of force majeure right. Not only do you need to make sure that it is in the contract, but you've got to review the wording to make sure it covers the sorts of risks that may occur. Now, if you were thinking 2 or 3 years ago, 3 years ago now, are we going to have a pandemic that's going to cause issues in the construction industry? Probably you'd say no. And so the drafting of that clause, whoever's drafting it really has to be able to see into the future and be a miserable git like me and be thinking, worst case scenario, what could happen here? And, you know, although we could have foreseen the Russian military operation in Ukraine, it had been threatened for some time, obviously, but eventually it happened. And so those with force majeure clauses that had badly worded terms in respect of war are going to suffer now. And so it's one of those clauses where you think that you're not going to need it, but in fact, over the last 2 or 3 years, we've had
two big reasons.
Yeah. And so it's really come to the fore. And it's something that clients really should be spending time looking at and considering.
And have you seen big changes in these, like on the lender side as well as on the construction side?
Yeah, I mean, I certainly see lenders being more conservative and wanting much fuller force majeure clauses and expecting the risks to be shown in that clause and to be thought through. I think if you'd gone back 5 years, lenders would be much more relaxed about it.
Yeah,
and it would have pretty standard wording, and no one really cared. Well, people care now, so I think it's something that, I mean, no one needs to worry too much about it because it's really a problem for the lawyers, but you need to be aware of it to make sure that your lawyer has covered it off properly.
Yeah.
So then that moves us on then to appointments and collateral warranties. Now, of course, as a developer, the likelihood is that your contract will be with the main contractor. But you want collateral warranties with their subcontractors. And the reason for that is to enable you to have a right to sue directly that subcontractor. Without the collateral warranty, that's very, very difficult indeed. And the classic example of when you need it is when the main contractor goes under and you want to sue a subcontractor for defective works, for example. Good luck. So make sure that you've got collateral warranties and make sure that they're worded properly and they cover you. And of course, in terms of appointments, you know, these are the contracts between you and the professional consultants. And I think these get overlooked a lot of the time. So either the consultants will offer their terms and conditions and the developer or the main contractor who's contracting with them directly will just sign up to them. And that's not good enough. Again, you should be reading them. And if you're directly engaging consultants, then you need to read their terms and conditions and preferably have a standard form appointment that they all sign up to for the reasons I gave earlier, so that you understand how the mechanisms in that contract work and say that it's industry standard and the risks are apportioned appropriately. The standard form contracts themselves are not in themselves good enough, so they need to be amended as well, but at least having them in standard form is a good start. But they do need to be tweaked, and the example I've given on in my notes here is, for example, the reasonable skill and care provision. Now, in the standard form appointments, sometimes it's just a basic statutory duty, and we would say that needs to be stronger, and it needs to benchmark what a reasonable consultant would do and raise that standard in terms of your expectations of what the consultants should be working to. Now, when everything goes well on site, it seems irrelevant. But actually, when, for example, your block of 150 units is finished and the roof is bowing, you need to be looking at your structural engineer and your architect. They're looking at each other, and you want those appointments and collateral warranties to be very carefully worded so that you have got a direct claim and you're entitled to issue proceedings against them. Carefully worded contracts. Who would have thought a lawyer would be saying that?
Yeah, exactly.
It's definitely worthwhile.
It's quite often for loans under, say, 2 million, lenders wouldn't insist on a collateral warranty. Would you still advocate?
Absolutely.
Yeah.
Have collateral warranties.
Yeah, yeah.
The cost of doing so is relatively low.
Yeah.
And I think it's from a risk position, you're increasing your risk unnecessarily by not having a direct right to sue the subcontractors. I think it's crazy, to be honest.
A lot of lenders will issue standard appointments and collateral warranties like text, and that they'll pass on and expect you to use. What's your thoughts?
Yes, so sometimes they can be well worded, but obviously you need an independent solicitor to review them. I would say that. Because it might be stuff that they've missed, or it might be that the solicitor who drafted the contracts for them has a different view as to what we do. And we like to think we're experts in this field, and whoever drafted that for them might not be.
Yeah.
Equally, the funder has got different concerns than you do.
Yeah, yeah.
So you need to have someone reviewing them to make sure that they align with what you need as well. Yeah, yeah.
And contingency?
So contingency, yeah. So this goes back to what we were talking about before, and I think it's probably more your game than mine, Ian. But when clients are coming to you and are seeking to raise money, they have a feel for what the contract sum's going to be. What do you advise in respect to contingency, and does it change depending on the nature of the development or the size of it?
So I think the industry norm now is closer to 10%. So pre-COVID, 5% was generally accepted, and lenders would be comfortable with that. But it's sort of inched up to 7.5%, and now it's pretty much at 10%. So for borrowers, obviously, that has a negative impact on their day one availability, because the contingency needs to be fully funded from the build loan portion. So from the total loan, the build loan allocation is greater, therefore the land loan allocation is smaller. So it does impact and therefore more deposits needed. But for the reasons we discussed, it's very important to have, especially at the moment. But we see sometimes with more specialist builds, so some barn conversions, things like that. We've sort of recently provided terms on. The lender's been asking for 15-20%, because there is perhaps a lot more unknowns in those kind of schemes than there are on something that's coming out of the ground. Yeah, I mean, gone are the days, when you can sort of rely on 5%, and some of the bigger schemes you might see even pushed down further to say 3%. I think if you're pitching 5%, a lender's gonna again query your credibility, because you're almost ignoring everything that's going on around you if you're quoting a 5% contingency. So yeah, 10% is good. I mean, the better developers that you speak to will, have built-in headroom into their contract sum, and then there'll be 10% on top. Yeah. So they're kind of double covered. And the thing to think about here as well is that that contingency amount will be funded from the loan before you get into a point where you're having to scrabble and find that money yourself. So it's, if you can find it up front, because as I said, it will mean the bigger the contingency, the smaller the land loan will be. But if you can find it up front, it will definitely allow you to sleep better at night. And you don't want to cash call partway through when perhaps it comes at a time where it's difficult to raise that shortfall. Yeah.
Okay. So the next section that I was going to talk about is essentially how you can pay as little money to construction lawyers as possible.
Giving away all the tricks tonight.
Exactly. And I do have a PDF that I can send, so please let Ian know if anyone wants a copy of the PDF, and we'll send it over.
We can send it out to everyone that registered, yeah.
Sure. Now, you know, part of our core values is cost transparency, and we like to think we're really upfront about fees and so how we charge and why we charge and things like that. And again, we've got videos that you can look at as to why we charge what we charge and essentially where the money goes. There's definitely things that you can do as a client to a construction lawyer, or indeed any lawyer, which will mean that you're paying them less. And so I'm just going to whiz through some of these points, which you can read more about in the PDF. So number one is maintaining excellent records. So poor client records mean that a lawyer essentially has to sort them out, try and work out what is what, takes more time, is obvious. In respect of your development, any development, you should be keeping electronic folders with subfolders of photographs, minutes of site meetings, any documentation in a really organized form, thinking that a dispute is around the corner. The reason for that is this: if a contractor starts an adjudication against you, you'll receive a notice of adjudication and a referral notice. The referral notice is essentially the claim and the particulars of the claim with the supporting documentation. Probably on the same day you'll receive those. You'll then have 7 days to put in your response, which is your defense. Now, 7 days goes very, very quickly. If you're not organized, then the likelihood is you won't be able to put in a very good defense, you'll lose adjudication. So it's really that important. Be organized and keep thorough electronic records. Going back to the point that I was discussing earlier about the importance of understanding the contracts that you enter into, understand the mechanisms. You're not expected to know them back to front, but have a feel for how they work. And again, we have some videos on the mechanisms in JCT contracts, which you can watch. And I think that then gives you a basis of knowledge, which means that when you're speaking to a lawyer, they don't have to start at point one. They can start a bit higher up, which saves you money. And it means that you're more confident in speaking to them about the issue and have a better understanding of it. So I think that's really important. Having an understanding of the law, the construction law in general. So for example, today I've spoken about the scheme. It's really important you know what the scheme is, because it plays such a crucial role in construction. So dig out our videos on that. Let me know if you want me to send you a video on that. Understand the acts which influence construction. And we're just going through at the moment legislative change. We've got the Building Safety Act coming in, which is going to have a massive impact on all building, basically. And it's a time of change for the construction industry in terms of law. And you need to have an appreciation of what those changes mean. You obviously don't need to read the acts themselves, which are frankly incomprehensible. And you can leave that to the boring lawyers. So when you're going to a lawyer, also be super clear about what you want to achieve, what your objectives are, and equally be clear on your instructions. So you're talking about objectives first. So what's the commercial outcome that you want to achieve? And really make that clear to the lawyer in your first conversation with them, and follow it up in an email to them. And every so often during the course of a dispute, go back to that email that you sent them and just consider whether this is going in that right direction in terms of achieving those commercial goals. And then being clear on your instructions means thinking about the issues and the chronology before you speak to the lawyer, having your emails in chronological order, having your folders and subfolders full of, in an organized way, of the right materials, so that on day one, your lawyer very quickly gets up to speed with what the issues are. A client's I think a lot of law firms are not very clear about how they bill or what the fees are going to be. Now, if you're instructing a lawyer in respect of contracts, they'll probably give you a fee range, and it'll be quite accurate. And there shouldn't be any surprises really, unless in negotiations it becomes really protracted. In respect of litigation, it's more difficult because obviously you don't know what the other side's going to do. So essentially, your lawyer should be able to give you a broad view on what it's going to cost, but with a caveat, obviously, that if the other side were to make an application to the court, you don't know what that application is going to be. In terms of adjudication, your lawyer should be able to tell you, roughly speaking, what it's going to cost you, because they know the work that is involved. I guess they'll probably update the fee estimate once you've sent them everything you have, all of the materials. But broadly speaking, adjudications cost what they cost, and that's it. And I think if you're not clear on what it's going to cost you, then don't proceed until you are clear, because this is a significant cost. It's going to affect net profit. So like any other costs within development, you'd want it nailed down and have a full understanding of it. Clients who are late in providing instructions or delay in providing instructions can cause lawyers to progress matters at a slower pace, or lawyers, for example, having to reread papers because it's taken so long for the client to come back to them to give them instructions on those papers. So be prompt in the way that you communicate with the lawyers. So talking earlier about the need to find an expert construction lawyer, and I'm not saying you should use me or Ridgemont. There are other expert construction lawyers, but definitely use one, because construction law is that area. It's so specialist that if you go to a generalist, I think there's a lot of risk that they're going to get it wrong. And it's probably going to cost you more money because they don't do it every day like we do. And so to some extent, they'll be reinventing the wheel and probably learning on the job, which is never a good thing. You need to use lawyers effectively. So what does that mean? Let's say that you've got a list of 50 items of defective works and you want to claim against the contractor in respect of those. If one of those items, let's say, is damage to sanitary ware, for example, or ill-fitting sanitary ware, let's say the remedial cost is £300, you need to think about whether the value of your time in instructing the solicitor and putting together the evidence on it, and the solicitor's time in considering it and advising you on it and pursuing it, is that going to end up in you losing money at the end of the day? So pick your fights on that one. So go after the high value items and think about leaving behind lower value items. It's just not cost effective to pursue them. Explaining who you are. So I think it's really important that your lawyer understands exactly what you do and what's been happening on site, so they have context and can fill in the gaps between what's missing in the papers and the photographs. And of course, we do occasionally get clients who don't follow our advice. So a lawyer's job essentially is this, and I think most law firms are not very good at it. The job as a lawyer is to present the options that your client has to move forward. And you should recommend one of those options as the way you would go if you were the client, because most lawyers are really scared of doing that, because what happens if they recommend one way forward and it goes wrong, then the client looks back at them. But I think, ethically speaking, a lawyer should say, if I was in your shoes, I would do that, because that's advising. Now, if the lawyer says that and you accept that they're an expert in their field, if you decide to act contrary to that advice, you need to look at yourself in the mirror and think, is this a good idea? I've paid an expert lawyer to advise me on this, and their advice was X, and I'm going with Y. Now, it could be there's a commercial reason for doing it, but if it's not, then you need to just think again. I think double think, like have another think about it before you take any action. So flowing from those points, a few action points that you need to keep in mind are keeping really meticulous electronic organized records, have a working knowledge of the contracts, have some knowledge of construction law, have really clear objectives and give clear instructions to your lawyer, understand the legal fees involved and how they'll be accrued, instruct the right lawyer, use lawyers effectively, explaining who you are and giving them context, and follow their advice. And I think those are the key action points which flow.
There we are. Yeah, I mean, solid advice, I think, in life, not just in regards to construction, right? Keeping good records. We had a session recently with a guy who's a first-time developer, and I was saying that in nearly 20 years, it's the first time I've ever seen a QS report come back in 4 days. And it's simply because the guy was very, very well organized. And, I think he was, like I say, first-time developer, no construction background at all, but the lender bought into him because of how organized he was. And had he not been organized, he wouldn't have got the funding. So, yeah, I think that's good advice all round. Cool. We've got there's a question that came up a bit earlier, which might be a good time to say it. So Chris May says, even if you choose a reputable contractor, things can go wrong. Are there any important points that you would put in the contract that is stopping any contractor from winding up the company? And would a contractor sign a PG perhaps?
It's a good question. I suppose there's many clauses within the contract that play around this. In terms of preventing a corporate entity from being wound up, that's incredibly difficult. And I think equally, getting a personal guarantee from a small contractor is probably going to be either impossible, or even if you get it, they won't have any assets in their name. So I would be careful about that. I think a much better way to proceed is to do your due diligence, do your credit checks and your financial checks, ask for the management accounts, like you said, great idea, and satisfy yourself that they're not going to be going under. I think if it's got to the point where you're halfway through the build and they're saying they're going under and you're trying to prevent that, it doesn't seem like a great place to be, does it? No.
I think you're probably too late, aren't you, at that point? Yeah. I mean, look, I think this session is makes it a bit more real for people, perhaps, and whilst it might seem like we're doom mongering, there are these things do happen, and I think it's great to be aware of these things, because for a lot of developers, you're risking bankruptcy effectively on each project, and you can probably back yourself to deliver a project, but you're passing a lot of that risk to other people. You're effectively providing a personal guarantee on a loan, which ultimately you have nothing to do with the performance of the project.
Yeah.
In a lot of cases. So you need to be really certain on these people, because you are by proxy effectively offering a personal guarantee on the contractor's business.
That's right. And I think, look, I'm not a doom mongerer, and I don't mean this session to make it sound like you're crazy if you go into development, because you're not. Everyone knows that if you manage things properly, there's great profit to be made in it, and it's fun. I suppose what I'm trying to say is have these things in the back of your head so that you proceed cautiously and you do the right things, which will minimize risk.
Chris has said, thanks for answering his question, and it's 1-1, by the way.
Right, phew.
So you might have a good second half. Okay, what else did we want to run through tonight? Okay, so Brickflow, hopefully most people on here know what we do. I will give a very quick demonstration for those that don't. So let me just do that quickly. Here we go. If you come to brickflow.com, whole idea of the app is to allow you to model deals before you get too heavily into the due diligence. So the way I sort of talk about it for me to make sense of it is I might have 10 sites that are on my desk at any one time. 8 of them probably don't make any financial sense for my situation. So rather than spend time on trying to do due diligence on 10 of them, run them through the software and concentrate on the 2 that might work. And so doing that is very straightforward. So let's say we're buying something at £1 million. We put our stamp duty and purchase costs in there. Let's say we're building in the Midlands. It's new build. We've got all of our commercial property types here, but let's say we're building something residential. And let's say we're building 20 houses. So put that in there. Let's say our build costs are 3 million. And we've got 20,000 square feet of house that we're building. And then we've got to put in anything that's not a core construction cost down the bottom here. So you'll see the contingency set at 7.5. You can up that to 10% if you want, or higher. But you can't go below 7.5 because there just aren't lenders accepting that at the moment. So 3 million, these costs generally, RICS will tell you it's normally 10% of that core construction costs. And then we've got, say, our GDV of, let's say, 6 million. And then you hit search loans, and you've got 26 loan options that have popped up there. And tells you your deposit, your profit. These are all estimates, of course, and what each lender will lend to you. So that's all there for you. You've got your check eligibility. So that then tells you what each lender is looking for from you and from the project. So there's information there on about the amount of deposit from you versus the amount of deposit can come from investors. The level of personal guarantee, any policy on pound per square foot, max unit price, whether they'll lend on permitted developments, air rights, listed, modular, that's all there. Whether they'll lend to first-time developers. So that information's all there. Once you are happy that you meet the criteria, then you hit shortlist. You can shortlist up to 5, and then you hit proceed, and you go through to the project appraisal part of the platform, which is where you then create a presentation which goes off to the lenders that you shortlisted. So you fill out these 4 modules. Once they're all complete, and I won't go into them now, but they're very easy to follow, tips and pointers throughout as to the information you need to provide. And then once you're happy with that, you click submit. Those up to 5 lenders receive an email that says, please log in, view a new presentation on Brickflow, and they're asked to submit their best terms on that project. And then they'll also provide any sort of conditions that need to be satisfied as part of the loan. So it really is that straightforward. I mean, myself and some of the guys in the office, end to end, we can do this in about 20 minutes, 30 minutes if you've got the information available. And that's normally a process for most people that takes about 6 weeks to search the market and make an application. So we're doing all of that in about 30 minutes. So we're happy to do all of that for you. So, by all means, just pick up the phone and we'll complete this with you. There's optional modules here which you can build out. So you can put your professional team in. So you could add John here if you want. But this is a project management tool. This is all information that you need to provide, and having it all in one place like we've been discussing today. Keeping good records is vital. So you can add all of your documents here. They will all live in the platform. You just click what to add. You can put your Dropbox links. You can put YouTube videos from previous developments. So all of that can live in the platform, and you can obviously communicate with us and with the lender through the note system. So yeah, definitely something to try if you haven't already. But anyway, back to where we were on the slides. Am I sharing the slides again? Or am I back? Am I still on the... Sorry, resume. I always get a bit confused. You
need to tidy up your desktop, Ian.
I need to tidy up my desktop. Oh, okay. Yeah, it's because my my printer doesn't connect unless I've got it saved to my desktop, which is really annoying. So these are some lenders that we got on the platform. So it's 38 today. I mean, pretty much everyone that you need to be working with in development finance. Some borrower and lender referrals or recommendations. This is something that we've just started, which is a Telegram group. And what we're trying to do here is really try and share contacts and experiences, knowledge. And I mean, it's very early days. I think we've got about 40 people on there at the moment, but there's already this week, one of the developers has got a site which he wants to get rid of. He's not going to develop it himself. So he's reached out to everybody else and said, does anyone want to buy it? There's a couple of agents on there that are land agents, and they're there to sort of help people along. So the more people that come on this, the better. But the only two rules are, when you come on, introduce yourself. So hit your QR code scanner, introduce yourself, and if anyone asks any questions where you can help, then please do. But people are referring contractors, architects, so there's a really good sort of beginnings of a community on there. So please do get involved with that. And there's a bit more on us if you want to get in touch. John, do you want to sum up? Best to reach out to you direct on this email at the bottom.
Yeah, I'm happy for anyone who's got any questions or wants to touch base to email me. And I think remember that see lawyers as reducing your risk and increasing your profits. That's ultimately what a good lawyer will do.
Yeah, look, it's there's a cost there, but using the right people is going to be a cost worth bearing. So I'll so somebody's asking for the slides. Damien, slightly tongue-in-cheek, I think, has said, gee, what a heavy session, who wants to be a developer? Yeah, thanks for that, Damien. And yeah, I'll send out the slides. John's going to send over his PDF, and that's it, we're done.
Good. Okay, well, thank you for everyone for joining us. I really appreciate it.
Yeah, Jill says, great session, thank you, can't beat a bit of law. Yeah, cool. All right, thanks, John, really appreciate your time.
Bye, everybody.
Yeah, we'll speak again soon. Cheers, guys. Bye-bye.
Bye.